Session, the Honorable Linda Cross presiding. Please be seated, remain quiet, turn off, and put away cell phones. Thank you. Good morning. All right, who do we have first? Good morning. It's not green. Yours is green? Is yours not green?
No, mine is not very working.
Oh. Okay, we got get that fixed. Okay. All right. Is this Broadus?
This is Colin. I also have Broadus, Moses Green.
All right. Well, let's do which one do you want to do first?
Collins.
All right. This is the matter of State of Ohio versus Summer Collins, case number B2601747. Ms. Collins is present in the courtroom with her attorney, Ms. Stephanie Lape, and Mr. Nick Croswell is present for the state of Ohio. This matter is on today for a pretrial. Ms. Lape, we have a jury trial date set August 31st and a final pretrial conference date set August 20th. Do you have any discovery yet?
Your Honor, I believe discovery is complete. I still need some time to fully review that.
All right, Mr. Croswell, can you speak to discovery? Do you believe that she has everything?
To my knowledge, yes, Your Honor, we were just talking. There is an interview in this. While she does have the body camera, I have not been able to confirm that the interview is on the body camera, but I will look that over. If it's independent of that, I'll give a copy of it to Ms. Lape as soon as possible.
All right. Ms. Lape, how do you want to proceed today? We don't have another date until the final pretrial conference in August. I'd like to, how do you want to proceed?
Your Honor, I would like another video trial in a few weeks.
All right, and let's just like a status.
Yes.
All right. Well, we already have our trial setting, so we don't need a clear trial setting. I guess I'll just set it for another pretrial, and the parties can work through and see where we are. Ms. Howard, July is really it's like most of the dates are already taken up. I'm out of town a lot for conferences, but we'll do our best. What do we have, Ms. Howard?
We have Thursday, July 16th.
Thursday, July 16th?
Thursday.
All right, Thursday, July 16th, 9:30. And is time waived until the trial date?
Yes, Your Honor.
All right. Ms. Collins, I'm going to ask you to please keep in contact with your lawyer. Make sure you're here on July 16th at 9:30, okay? All right.
Thank you, Your Honor.
Anything else?
No, Judge, thank you.
All right, thank you. You want to do Mr. Broadus now?
Mr. Ramsey's on that one?
Oh, Mr. Grampier
He
is on that.
stepped down, but I'm not sure.
Okay. All right, we'll wait till he gets back. All right.
Dia, Your Honor.
Okay. This is the matter of State of Ohio versus Jabril Dia, case number B2601144. Mr. Dia is present in the courtroom with his attorney.
Morning, Your Honor. J.R. Bernanke standing in for Alex Hewitt.
Okay, what's your name?
J.R. Bernanke.
Branton?
Bernanke, B-E-R-N-A-N-S.
Oh, okay. Nice to meet you. And Mr. Nick Croswell is present on behalf of the state of Ohio. So this is on for a pretrial. Counsel, we have a trial date August 3rd and a final pretrial conference date July 16th. Let's see, I think the last time Ms. Deardorff was here, she said discovery was completed already.
It was that she went back and started reviewing everything, found out the videos that she had appeared to be from another case.
Oh.
She does not have video. I let the state know and said we would look into that for the right video. Other than that, there are no issues.
All right, Mr. Graham, Mr. Croswell.
I'll double check it. They were sent video, it might have been either, I'm not sure the wrong one was sent, or see if the records got the wires crossed, but I'll clarify that, get that to Mr.
All right. So at this point, it's just a video that may be outstanding. All right. So we have a final pretrial conference next month. Do you foresee a need to put anything on the calendar before July 16th?
We do not.
All right. Well, we'll continue this as already scheduled for the final pretrial conference, July 16th. Mr. Dia, please keep in contact with your attorney, Ms. Deardorff. All right. And then, okay. All right. And then I'll see you back here on July 16th at 9:30. All right. All right. Time wave.
Time wave.
Thank you.
Thank you, Judge.
And then I can't hear either. I can't hear out of here. Nothing's coming out of here. All right. Anybody?
I'll have to call them. It seems like none of the speakers are, like the sound system as a whole is offline somehow.
Oh, that's gonna be hard today.
I will, let me give them a call.
Okay, thank you. We'll just amplify our voices. All right, Mr. Nicholas, are you ready? Okay, all right, no problem. Just trying to get people on their way. Mr. Guyman, you ready? Okay. I just want to get people on their way. Mr. Gustafson, you ready?
Yes, Your Honor.
Okay.
I'll be back.
Mr. Johnson here? Oh, there he is. All right, this is the matter of State of Ohio versus Cecil Johnson. Case number B2507238. Mr. Johnson is present in the courtroom with his attorney, Mr. Derek Gustafson, and Mr. Nick Croswell is present for the State of Ohio. This matter is set for a sentencing. Mr. Johnson was entered a guilty plea on April 30th to count one, a single count in the indictment, having weapons while under disability, a felony of the third degree. And the court ordered accepted his guilty plea. And I ordered a PSI, pre-sentence investigation report, as well as a River City evaluation. And counsel, have you received a copy of the pre-sentence investigation report? All right. Mr. Croswell, have you had a chance to see it?
Yes.
Okay. And think I got anything from the River City. I don't have anything from River City. Mr. Johnson, River City evaluation was requested. I don't think I had. Have you seen anything, Mr. Gustafson?
No, I just, PSI says a referral was made. but
Yeah.
I don't know the regulations.
All right, well, we got to see where that is. And I also reviewed a sentencing memorandum filed on behalf of Mr. Johnson by counsel dated May 28th, 2026, and I did review that. So, counsel, we're waiting on the River City statement. Do you want to wait for that, or do you want to go forward? We should get it hopefully momentarily.
Yeah, we can also second judge, that'd be fine.
All right, thank you.
Okay.
Call Mr. Anthony, the judge, court available.
Okay. This is the matter of State of Ohio versus Cornelius Anthony, case number B260170. Mr. Jeff Guyman is present on behalf of Mr. Anthony, Mr. Nick Croswell for the State of Ohio. This is a pretrial conference. Mr. Guyman, your client is in the Justice Center. Would you like to have him brought over? All right. I'll allow you to waive his presence for today. We have a final pretrial conference date set August 20th and a jury trial date set August 31st. Do you have discovery on behalf of your client?
I have.
All right. Do you believe that it's completed?
I do.
Okay. Mr. Croswell, do you want to speak to that? What was turned over? Or?
No, it's been turned over, Your Honor. We're in plea negotiations. I believe Mr. Guyman has accepted this for a plea setting.
Okay. So discovery completed. And we need to set this for a plea?
Correct. Judge.
Okay. All right, set it for a plea. While we're looking for a date for a plea, why is he incarcerated? Because he was on a bond, OR bond from our court.
You want to, you gotta have some pending matters that Judge Johnson can resolve. You got sentenced.
Oh, gotcha. Okay. All right, we're looking for a plea date on Mr. Anthony. As soon as we can get it. Preferably this month, since
Possibly do it. June 17th.
Wednesday, June 17th.
That was short.
All right. We'll set this for a plea Wednesday, June 17th, 9 a.m. Is time waived?
Yes.
All right. We'll see you and your client back here with the plea documents already completed, June 17th, 9 a.m.
Thanks, Judge.
Thank you, Mr. Guinan. Do we know what happened with River City?
She said we should be eligible because he's been there before. He's witness.
Okay, what happened to our evaluation?
They didn't, she said they didn't get anything. I don't know why, because I put it on the run sheet.
Oh. Okay, so when's he gonna call us back? I'm waiting to.
No, she just, that's what I'm telling you. She said she's gonna send a letter on that.
Okay,
But she said he's eligible.
all right,
Because he's been there before.
okay. Ms. Slate, you ready?
Yes, Broadus.
This is a matter of State of Ohio versus Levantes Broadus, case number B26011727. Mr. Broadus is present in the courtroom with his attorney, Ms. Stephanie Lape. Mr. Nick Croswell is covering for Mr. Gramke for the State of Ohio. And this is a pretrial conference. Ms. Lape, we have a jury trial date set September 14th and a final pretrial conference date set September 3rd. Do you have discovery?
I did not have discovery yet. I spoke with Mr. Gramke this morning, and he believes he has most of the discovery and intends to get back to me promptly.
All right. So we obviously need another date sooner than later to make sure you have that. Ms. Howard, when can we get another date for Mr. Broadus?
We could do, Wednesday, July 8th, or Thursday, July 9th.
July 9th, Tuesday.
All right, Thursday for pretrial, July 9th at 9:30. Is time waived at this time?
Yes, Your Honor.
All right. Mr. Broadus, please keep in contact with Ms. Lake, your attorney, and we'll see you back here July 9th at 9:30. Okay? Thank you.
Thank you.
All right, let's recall Mr. Johnson. All right, this is a matter of Cecil Johnson sentencing. So all the paperwork was done correctly to request the River City evaluation. Apparently, there was a glitch and they didn't get the request, but they've looked at, he's been there before and they looked at his record and all of that, and they say he is eligible for River City. They're going to send a letter to that effect momentarily, so I just wanted to let you know. All right, would you like to proceed at this time? All right. What would you like to say on behalf of Mr. Johnson?
But Judge, I don't have too much other than what's in the sentencing memorandum. I do want to make the court aware that I made a mistake on the sentencing memorandum. I misread my notes. I stated to the court they had 3 children, ages 2, 3, and 9. Apparently, my notes were they had 2 children, ages 9 and 3.
Oh,
So that's the mistake here. I did note in the PSI that there was a warrant from Kentucky for a case that no disposition was. It was actually not a case filed in Kentucky in 2024. It was on PRC supervision. A misdemeanor charge was filed here in Ohio. The parole officer issued the warrant, which then Kentucky executed because the parole Kentucky brought back to Ohio. The Ohio case, which was the basis of the warrant, was dismissed. There's no conviction. That's what's in the PSI. I would note that my client has contacted Fortis to enroll in their HVAC program. He is not enrolled in that because of not knowing what the court would do with sentencing. He didn't want to enroll and start and not be able to review it to go. So his plan is if this court were to place him on community control status without a local incarceration, sort of incarceration, he would start that program as soon as he would.
and what type of program is it?
It's service and maintenance of HVAC.
Oh.
Heating, ventilation, air conditioning.
Yeah, when would he start that program?
I want to say like the eight people at this case, I already wrote and everything. I just ain't like go to school. I just took my report today.
Where's the school?
It's what is it? Forest College.
Hmm?
Yeah, it's Forest College.
Oh, okay. Where's that at?
I want to say. Westchester.
Oh, in Westchester. Okay. I was just wondering, because I run a reentry program and one of our participants just finished the HVAC and got their certificates and all of that. And we went to the graduation. I was wondering about that one because I've never heard of that one. But okay. All right, go ahead.
That's all I have, Judge.
All right. Mr. Gramke? Anything on behalf of Mr. Croswell? I'm so sorry.
I'm not sure if you're aware of the factual pattern around this case, Your Honor. One was not charged, and I defer to you, but I consider it or not. Officer did respond to a shot spotter incident. Drones had a description of the individual matching the defendant running with a gun in his hand. He fled into a protected party's residence. I don't believe that person showed up at grand jury, so there was no TPO violation. However, there is some more collateral things. If you want to consider that, Your Honor, was not charged, but there was a suspicion of him using that firearm. There were no formal charges.
Judge, with respect to the allegation that there was a TPO violation that was not prosecuted because the victim didn't show a grand jury, it's actually to be a child. She's here in the courtroom. She appeared in Rebecca and showed the protection order at issue. It actually expired in December of 2025. Apparently, the fact that the order expired is not consistent, so I believe that's the reason it's not. I think it's fair enough.
Okay. All right, Mr. Johnson, anything you'd like to say before I pass sentence? You've been to prison once. You've had no probation history and therefore no violations of probation. You have been on parole before and you successfully completed that. You're working and earning income. And you live with your two children and their mother. You completed your GED. Usually I get some type of information from the officer. Officer has an opinion or just facts. The officer, nothing this time. I am concerned about a couple of things. One, your substance use, as stated in the PSI, twice a day. If I would have put you on probation, you couldn't do that. You understand? I know there were lots of domestic cases filed against you, but dismissed. I'm concerned about that. I know they were dismissed, but the fact that you've had several tells me that there's something going on. Don't know. It just raises alarms for me. But I will say the last one was early 24. The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors as set forth in Revised Code 2929.12. Accordingly, Mr. Johnson, I hereby sentence you to a term of 3 years of community control intensive supervision. You will have to submit to drug and alcohol testing. Is that going to be a problem? Okay, because that'll be a reason why you would violate probation, which I know you've never been on before. It's an immediate violation of probation, which could send you to prison. Do you understand? All right. So 3 years community control, intensive supervision. You will pay court costs. There will be no fine. And if you violate the conditions, let me tell you the good news first. If you do well, I will consider shortening the probation time. Okay? The worst case scenario is if you don't successfully complete probation, then I will not hesitate to sentence you to a term of 3 years, 36 months in the Ohio Department of Corrections. Do you understand? All right. Anything else, counsel? State? All right. You have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Now, I know where you live, and that may have something to do with why you thought you needed to have a gun. Do you still live there? Okay. But you're not permitted to have one. All right. And so I don't know if you and your family need to move. I know the housing market is pretty rough right now with rent going up very high, but you need to do what you need to do to protect you and your family without a gun. You understand? All right. And so you'll need to go over to probation right after court, and they'll sign you up. We'll send over the paperwork ahead of you so you won't have to wait, and then you'll be done. Okay? All right. Thank you. Drug and alcohol testing, please. Well, I just have to remind you because you sometimes say, I didn't hear that. So I got to make sure we're on the same page. All right, who do we have next? Where's Mr. Kaplan? Mr. Jones? Miss, okay. You're waiting on your client. Mr. Jackson's not here. You ready? Ready? Anybody ready? Miss Marinakis?
I've had my client down to that shit.
Okay, is he on his way down?
I don't know what's coming down to that shit, I don't know.
Okay, we get to tell Miss Howard, she'll call him down. Miss Howard, who's on their way down?
Mayor,
Who's on their way down?
Mr. Jones' case.
Okay.
Here in the law.
Ms. Roth, are you ready?
Judge, I don't know the status of the outstanding video.
Okay. Okay, so you need to talk to Mr. Croswell. Okay. All right. So Mr. Jones's client is on the way down Monroe. I need a motion for bond from Monroe, and I don't have the file. I don't have a file from Monroe, and there's a motion for bond. I'm wondering why. But we had got all this together on Friday. She's very, well, thank you. This is the matter, good morning. This is the matter of State of Ohio versus Garrett Monroe, case number B2600978. Mr. Monroe is present in the courtroom with his attorney, Mr. Robert Jones, and Mr. Nick Croswell for the State of Ohio. This matter is on today for a pretrial, and there's a motion for bond pending. Mr. Jones, we have a final pretrial conference date on July 30th at 9:30, and a jury trial date August 3rd, July 30th and August 3rd for the trial date. Do you have discovery yet?
No, Judge, this is our first appearance in front of Your Honor. We were previously with Judge McDowell. While this case was pending, McDowell's room, I didn't receive any discovery, but I just talked to Mr. Croswell. He believes we'll be able to get discovery moving pretty soon, pretty quickly.
Okay. Yeah, I saw this was in front of Judge McDowell. He had a conflict.
Correct.
Okay. All right. So, Mr. Croswell, can you speak to the discovery issue?
Judge, informal has been given to Mr. Jones. I will confirm though what has been sent him previously and get him actual formal, probably sometime this week.
Okay. Mr. Monroe has been in custody for 50 days.
No, he was previously released on bond, Judge, and then he was arrested by his EMD officer at his house, and he's been held on a no bond for about 2 weeks now, 10 days perhaps, on a no bond because Judge McDowell wouldn't hear the reinstatement request that we filed. So he's been held on no bond for the last 10 days.
Okay. All right. Well, since discovery is outstanding and the next date isn't until July 30th, let's get a date on the calendar between now and then so that we can make sure that discovery has been exchanged. Ms. Howard, can we work on getting a date? And then Mr. Jones, in the meantime, you want to address the motion to reinstate the original bond?
Yes, sir. So the original bond was $5,000 at 10% EMD open hours. We're asking for the court to reinstate that previous bond. And the basis for that is, despite the violation, EMD officers came into Mr. Monroe's home and they saw what they believed to be narcotics. And that's all that's in the bond motion, or in the violation motion. But there's been no charges filed. So we just had this allegation of narcotics, which Mr. Monroe is denying that they were illegal substances. He actually told them what he believed they were, that they were baking soda, that they were putting into the shelves. But I think regardless of that.
Oh, wait, it was baking soda doing what?
You put in cabinets to make sure it doesn't start on the refrigerator, sorry. So you don't get the stale smell.
You mean a box of baking soda that you buy from Kroger?
Correct.
And the box was in the, oh, it wasn't packaged like that? It was packaged like what, baggies?
And they took it off the inside of the refrigerator. They thought it was drugs, but I told them it wasn't.
Was it in the baking soda box?
Yes, it was behind the baking soda box, like it got tipped over. But it was not drugs. I told them it wasn't.
Oh, you're saying what? It was loose baking soda
Yeah.
in the refrigerator
Yes, ma'am.
behind the baking soda box?
Yes, ma'am.
I see. Okay, go ahead.
Judge, since this violation, the officers, partners with law enforcement, there's been no charges filed, so I don't know if they tested this substance, but regardless, it hasn't come back with a new offence. Considering Mr. Monroe's statement, this wasn't a legal substance, and we have no new charges, we'd be asking for a reinstatement of the previous bond. It wasn't like Mr. Monroe eloped or ran away or was violating the hours. He was actually in his home where he was supposed to be with his fiancée, who's in the courtroom today, and they have numerous children together with the judge. The hours out that Mr. Monroe was allowed was because he was a very involved father. He was taking the kids to school and from school, and he was working at a landscaping company while he was out on the box. And he did have a job prior to being arrested on these offences, but because of the box, he wasn't able to maintain that employment, so he's working for a landscaping company right now, Judge. These charges are felonies of the fifth, most extreme charges are felony of the 5th degree, which, is a low-level felony offence. We believe that Mr. Monroe should be detained while we work out the resolution of these matters. So I think all in all, Judge, will be able to, as I said, reinstate his bond. He was complying with all the E&D hours that were set upon him, and there was no issues with the E&D officer in terms of showing up late or going where he wasn't supposed to go. It was literally an allegation of illegal substances that didn't lead to an indictment or any misdemeanor charges. So for those reasons, Judge, we ask that Mr. Monroe be reinstated as previous bond. We'll show up at all future court dates, Judge.
All right, State.
Your Honor, this is a F by obstruction to the traffic stop. He became combative with the officer, struggle ensued. Officer actually struck his head on the pavement and was knocked unconscious for a period of time. He does have a series or several prior felony convictions the last few years, coming for report on his bond.
Okay. Is there any potential testing of the substance? Because this looks like it happened on April 28th. And so I know usually when they do the testing, it takes a while for labs to come back.
I did not know, I was unaware of the EMU violation, that whole part of it until a moment ago. I could try to find out who the probation officer is and see if they involve law enforcement in that, got it tested, or what the current situation is.
Tim Palm. Palm, P-A-L-M.
I can look and see what going on that day.
Yeah, that we need to.
And I'll call Mr. Jones and let him know what I find out.
So the allegation of the EMU violation was the home visit, as you stated, Mr. Jones. And it says 11.75 grams of a white powdery substance suspected to be narcotics. But not just that, it says along with drug paraphernalia. Syringes were found. And in addition, it says they allege that not only did, they found that, but that Mr. Monroe failed to let the officers into his phone, which is a violation of the EMU rules. So. Well, you might not want to say anything. Talk to tell your lawyer what you want to say first.
Mr. Monroe have discussed this previously with the judgment down. So the phones that they were requesting to get in weren't Mr. Monroe's phones.
Oh.
So he didn't have the authority to let them into the phones that weren't his. And that's with syringes. There was another individual in the house who was using them for means that weren't illegal drug use.
Use them for means of work?
No, for testosterone.
Oh. Can we get Mr. Palm on the phone for a moment? I'd like to at least see what the status of that situation is. If they're doing nothing with it, then that leads me in one direction. But if there is something, then it may lead to another. I'd really like to know before I make the decision. So, Mr. Monroe, can he just have a seat for just a moment, and then you guys can talk to the probation officer? Okay, thank you. Mr. Nicholas, you ready?
This piece is in the hall.
That's a good food.
Very clear.
Oh, okay. Ms. Roth, are you ready?
We still have the outstanding issue. I've spoken with him about it, but he's taken another step.
Oh, okay, there's another step to take. Oh,
Yeah, we would need to speak to somebody.
okay. Well, perhaps I need to let you do that before I do this plea.
We're gonna wait for this.
Did you get in contact with Mr. Paul?
I'm texting him now.
Okay.
He answers, he's gonna be supervising.
That would be.
If we approach it once.
Yep.
There's a victim on this, she's here, we know what she wants, but we're okay with her in PSI, but I didn't know if that was something you were okay with, so I figured I'd ask now before we got to the We don't need one.
You don't need-
No, we're just gonna run away from essentially unless you would prefer. Yeah, I would agree.
Yes.
Ex-girlfriends got broke up, got angry, was ramming in the back of a car with it. The victim got out, and then the accident, she believes it was an accident, got struck with the car when she was there. Yeah, victim said the defendant was ramming in the back of victim's car. The victim was in the car. She got out. I think it's intentional, but I'm not sure entirely, but got in the middle of the car and got hit. Minimal injuries, bones bruises, no restitution.
Yeah.
So, the aggravated assault, heat of passion, breaking down, got hit.
Well, the victim came in, originally came in, jury didn't want to charge. Didn't want to charge. Unfortunately, they tried to cancel out, that didn't work, so here we are.
Oh, because we couldn't make it out. Yeah. You know, after this case,
It's been months. And they've been, I think they're-
okay.
Yeah.
All right.
Maybe. We'll see.
All right. Mr. Jones, we're still working on it. We're still trying. I want to get your case out because I want the officer to be able to go somewhere else too.
I'll hang it out.
All right. Well, I'm going to go ahead and let you guys get with Mr. Palm later because we can't get in contact with him for some reason. And so just,
He's not until 2:00.
he's not in till 2:00. Okay. Well, Mr. Nicholas, let me just finish with Mr. Monroe real quick, and then I'll call you back up. All right. Well, it's been over 30 days since that happened. Don't know what the state is going to do yet with regard to any testing or if it truly was what it was. Don't know. What I'm going to do is I'm going to, at this time, grant the motion to reinstate the bond. The bond will be the 5,000 at 10%, with EMD, but it's not gonna be open hours. Does he work? Where?
Great Escapes, Montier.
Okay. So this is a time of year where you're probably doing a lot of lawns, but you're not doing lawns at 9, 10, 11, 12 o'clock at night. So we're gonna do, what time do you usually start in the morning?
About eight in the morning. I get picked up around 8:30.
All right.
I'm done when the sun goes down.
Yep. All right, so, previous bond, 5,000 and 10% with EMD. The hours are now 8 to 8, 8 a.m. to 8 p.m. Monday through Sunday. Make sure you keep your job. And, we'll see you back here. We need a pretrial date, Ms. Howard.
Either July 1st or June 25th.
July 1st or June 25th.
I'm available July 1st.
Wednesday, July 1st.
Wednesday, July 1st, 9 a.m., time waived.
Yes, Judge.
All right, Mr. Monroe, keep in contact with your lawyer. And remember your conditions of electronic monitoring. They can come to your house. You understand that? All right, so we will see you back here July 1st at 9 a.m. You're still gonna be on EMD. All right, thank you. All right, Ms. Dukes. Thank you. All right, no problem. Ms. Marinakis, what you know what you're gonna do yet? Need more time?
Gonna ask for continuance this morning.
Oh,
I dropped one, I gave Ms. Howard one.
oh,
This is the voucher.
yeah. Don't go anywhere, Mr. Nicholas. Don't go anywhere. All right. Do you want your client brought down
Yes, please.
for this? Okay. So Ms. Howard, you're gonna bring Ms. Marinakis' client down next?
Yes.
Okay, perfect. All right. This is the matter of State of Ohio versus Mayana Dukes. Is that how you pronounce your name? All right. Case number B2506410. Ms. Dukes is present in the courtroom with her attorney, Mr. Doug Nicholas, and Mr. Nick Croswell for the State of Ohio. This matter is on today for a jury trial, but I've been handed plea documents. Counsel, is this how your client wishes to proceed?
Yes, sir.
All right, Ms. Dukes, is that accurate? You want to proceed by way of resolving your case by way of a plea of guilty?
Yes, ma'am.
All right. Are you the Mayana Dukes named in this indictment?
Yes, ma'am.
Ms. Dukes, how old are you?
I'm 21 years old,
How far did you go in school?
graduated high school.
And so you're able to read and write the English language well?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Have you ever served in the military?
No, ma'am.
Ms. Dukes, I have in my hand a single-page document. It's entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Mr. Nicholas's signature here. Right above that, is that where you signed?
Yes, ma'am.
Can you see it from here?
Yes.
Okay. This is an acknowledgement by you that you understand that you have a constitutional right to have a trial. But when you sign this form, you're indicating to the court, I understand that. I know my constitutional right, but I don't want to have a trial. Is that your understanding of what you were doing when you signed this form?
Yes, ma'am.
Did you sign this form after consulting with Mr. Nicholas about your constitutional right to have a trial?
Yes.
You have any questions about this form?
No, ma'am.
Do you have any questions about your constitutional right to have a jury trial or any trial?
No, ma'am.
Okay. I also have in my hand a 3-page document, 3 pages, and it's entitled Entry Withdrawing Plea of Not Guilty, Entering a Plea of Guilty. And on the third page, there are signatures. I recognize Mr. Croswell's signature there. Mr. Nicholas's signature here, and right up here. Is that where you signed?
Yes, ma'am.
All right. Mr. Croswell, would you please put on the record the party's expectation regarding this plea?
Your Honor, in exchange for a plea of guilty, the state is going to seek to amend and reduce this to an aggravated assault felony of the fourth degree. The prosecuting witness is here in court, as the officer was as well. They're both okay with that plea arrangement.
All right, thank you very much. Mr. Nicholas, is that accurate?
Yes, Your Honor.
Ms. Dukes, is that your understanding of what's happening today?
Yes, ma'am.
All right. Are you under the influence of any medications, any alcohol or drugs today? Do you now, or have you ever had to manage any type of mental health difficulties?
Yes, ma'am.
Can you tell me a little bit about that? What were you diagnosed with?
I had really bad depression growing up. I was in counseling majority of my childhood up until the age of 17.
Okay. And were you prescribed medication to help you manage that diagnosis?
Yes, ma'am.
All right. Are you still under a doctor's care?
No, ma'am.
Are you still prescribed the medication to help you?
No, ma'am.
Okay. Did you stop, or did a doctor terminate your medication regimen?
I stopped, and I also lost doctor care basically. I didn't have a doctor anymore because I ended up moving states.
Okay, so you didn't have medical coverage.
No,
I see. All right. And so right now, you don't have that medication anymore.
no, ma'am.
All right. How long ago has that been?
About 5 years.
Okay. All right. And so any other diagnoses?
I have ADHD, and that's really all.
Okay. And so ADHD, were you diagnosed that when you were in school?
I was diagnosed during school.
During school?
Yes.
All right. And were you prescribed medication for that diagnosis?
Yes, ma'am.
Okay. And are you still taking that medication?
No, ma'am.
All right. Thank you. Are you presently under any type of probation or community control supervision in this state or any other state?
No, ma'am.
Has anyone forced, threatened, or coerced you in any manner into entering into this plea of guilty today?
No, ma'am.
Has anyone promised you anything at all if you enter into this plea of guilty today?
No, ma'am.
Are you making this plea of your own free will?
Yes, ma'am.
Now, the state has indicated this is a single count indictment for felonious assault, a felony of the second degree. In our system, the highest is a felony of the first degree. You're charged with a felony of the second degree. Then there's a third, fourth, and fifth. But based on your attorney's negotiations on your behalf with the state is asking that I reduce the charge from felonious assault, a felony of the second degree, down to an aggravated assault, a felony of the fourth degree. Do you understand?
Yes, ma'am.
And is that your understanding of what's happening today?
Yes, ma'am.
All right. Did you have an opportunity to go over this 3-page plea form with your lawyer before this hearing?
Yes, ma'am.
Do you understand what it says?
Yes, ma'am.
Do you have any questions about it?
No, ma'am.
Did Mr. Nicholas answer all of your questions about it?
Yes, ma'am.
Ms. Dukes, do you believe you've had enough time to sufficiently consult with your attorney about your entire case before this hearing today?
Yes, ma'am.
And has your lawyer answered all of your questions to your satisfaction?
Yes, ma'am.
Have you had an opportunity to either review or discuss the evidence with your attorney that the state has against you before today?
Yes, ma'am.
All right. Mr. Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any, to your knowledge, to the defense?
To my knowledge, it all has, Your Honor.
All right. Mr. Nicholas, do you acknowledge receipt of same?
Yes, sir.
All right. Ms. Dukes, are you satisfied with your lawyer, Mr. Nicholas?
Yes, ma'am.
Now, do you understand this charge that's been reduced and amended to aggravated assault, a felony of the 4th degree? Do you understand that charge? And do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the offense of aggravated assault, a felony of the 4th degree? And do you understand that if you plead guilty to this offense, the court may enter a judgment of guilt against you and proceed to sentence you immediately? Now, Ms. Dukes, this being reduced to a felony of the 4th degree, do you understand you're facing up to 18 months in prison and up to a maximum fine of $5,000? Do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years? Do you understand that? And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand? Are you on post-release control right now? All right. Well, do you understand that if you are on post-release control, so what I'm telling you now is, if I were to sentence you to prison, you get out of prison on post-release control, and you commit a new felony offense, okay? That's the scenario I'm talking about now. If you are convicted of a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term, or whatever time remains on your post-release control time, or whichever is greater. Do you understand?
Yes, ma'am.
All right. Do you have any questions so far? Since this is being reduced to a felony of the 4th degree, community control or probation is a possibility. Do you understand that I could place you on community control or probation for up to 5 years instead of sending you to prison?
Yes, ma'am.
Do you understand that if you are placed on a community control sentence, you would have to abide by all probationary conditions as established by this court?
Yes, ma'am.
And if I place you on community control and you violate the conditions of community control, then you're going to be brought back before me for a more restrictive sanction, which could include a whole host of penalties. But the most severe penalty could be the imposition of prison time, up to the 18 months I previously told you about. Do you understand?
Yes, ma'am.
All right. Also, if I impose court costs and you fail to pay those court costs, I could just order you to do community service instead of paying court costs. Do you understand that? All right. Now, Ms. Dukes, first of all, do you have any questions? If I were to place you on community control or probation, I would fully expect that you would comply and be successful. But can I tell you a few ways that people are not successful? The first way is that they commit a new offense. That's an immediate and direct violation of probation. Do you understand?
Yes, ma'am.
The second biggest way is that people just don't comply with all the rules. So there may be 5 rules and they could comply with 4 or 4.5. That's still a violation because you didn't complete all 5. Do you understand? And then the third biggest way people violate community control or probation, which is not so commonly known, and that is they leave the state without permission of the court or probation. Do you understand? So if you're on probation and you're like, well, I'm going to go to a family reunion and we're going to be in Florida. Well, you have to get permission. Do you understand? And because we're so close to Northern Kentucky, Kentucky is a different state, and Indiana, going even across the river is a violation without permission. Do you understand that? All right. Any questions? When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, which was set for today, to either the court or a jury of 12 persons? Do you understand? Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer? Do you understand that? Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify on your behalf? Do you understand that? Do you understand that at a trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt? Do you understand that? And finally, do you understand that at a trial, you cannot be forced to testify against yourself? Do you understand that? Do you understand each of these rights as I've explained them? Do you have any questions about your constitutional rights? Do you have any questions about anything we've discussed here today? Do you understand that if you plead guilty to aggravated assault, a felony of the 4th degree, that you are waiving or giving up all of these important constitutional rights in this case? All right. Ms. Dukes, knowing everything the court has explained and talked with you about, do you still wish to enter a guilty plea to the reduced and amended charge of aggravated assault, a felony of the 4th degree? Counsel, is there anything further before I accept the plea?
Yeah, you're right.
May I hear a statement of facts?
Your Honor, this occurred on or about November 14th, 2025, Hamilton County, Ohio. On that date, time, and location, the defendant, while under the influence of sudden passion or fit of rage, brought upon by sufficient provocation to cause serious physical harm to Miss Jalila, Jahila McCarter, McCarter.
Thank you.
Wait for the reading.
Yes.
All right, thank you. Anything on those facts, counsel?
Nothing.
All right. Ms. Dukes, did you hear what the prosecutor said you did?
Yes, ma'am.
Is it true?
Yes, ma'am.
What is your plea to count 1, reduced and amended to aggravated assault, a felony of the 4th degree? Let the record reflect that Ms. Mayana Dukes was present in court with her attorney, Mr. Doug Nicholas, and that Ms. Dukes was informed of all of her constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Ms. Dukes understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Ms. Mayana Dukes guilty as to count 1, aggravated assault, felony of the 4th degree in violation of revised code 2903.11 subsection A2. All right. Counsel, is there any reason why sentence should not be entered today?
No.
Are you waiving the PSI?
Yes.
All right, and we have the victim here.
Yes, she is here, Your Honor.
All right, and does she want to address the court?
Ms. Carter, you want to address the court also? She did not address her previous, Your Honor. We can handle it without her.
All right. What would you like to say on behalf of Ms. Dukes?
Judge, Mayana's 21, she'll be 22 in 2 weeks. She lives in Fairfield, grew up down in rural Kentucky. She's a graduate of Dawson High School. She's completed nursing school. The only thing she has left is to finish the test. She's been working for the post office as a clerk for the past 9 months. Judge, she's extremely remorseful. We've been trying to resolve this, quite frankly, for months. And I don't know what the order was, and they just couldn't get a hold of Mr. Porter, but be that as it may, this wasn't something that she was trying to drag out. She was trying to resolve this because she is very sorry for what happened. Judge, the alleged victim, my understanding is they're not asking for restitution or probation. She came to room 585. She contacted me, quite frankly, went there to get the protection order, the no contact order lifted. Having said that, I don't think the two of them did in much contact. Lastly, Judge, Ms. Dukes has no record to speak of. The pretrial services report we got back in November showed one misdemeanor in those boxes, but then when you flipped it over, I have no idea what it was for, but no felony contacts, no contacts out of state, no juvenile contacts. So with that, Your Honor, we would ask that the court place her on a period of community control.
All right, thank you. State.
Your Honor, Mr. Nichols is correct that no request for restitution, no medical or car. Victim indicates her wishes on this would be that Ms. Dukes get treatment, whether that's mental health, anger management, or mental health that's recommended by probation. That was her wishes, also well to stay away. She is okay with probation to accomplish those needs. The only thing to add is that I believe the defendant is on probation to Judge Mallory, 2025 criminal damaging. I'm not sure if that's been resolved or the PV filed on those, but it looks like she's still on paper to Judge Mallory.
Involving the same victim?
I do not know. I forgot to follow up on that. But October 31st, 2025, to given 2 years probation.
Okay. Ms. Dukes, anything you want to say before I pass sentence?
Just 1 second, if I may. It sounds like the probation was terminated. I think it might have been violated as a trigger in this case. Judge Mallory just said she was allowed this court to handle whatever the outcome might be. So Ms. Dukes indicated that she's no longer on any probation.
Same victim?
No.
All right.
Yeah, I'm sorry, but the victim would like to speak at this point.
Okay.
May I come forward?
All right, step to the side. If you all just step to the side. Thank you. I need sentencing findings for Dukes, please. I don't really prepared for that. What is going on? All right, ma'am. What is your name? Jalia? Jalia? All right. And what would you like to say, ma'am?
Far as the same stuff I said outside, far as like,
I don't know what you said outside, so you got to tell me everything.
just getting her help is the main focus.
Okay. So you're just looking for her to get some help?
Yeah.
In what way?
As far as the anger stuff, and just, I don't know which way certain the state can help, but like mental health. That is like just a mental health problem as far as like trauma and stuff that results in passion as a mental. That's
Okay. How long were you in a relationship?
It's like a situationship.
A situation, I've heard that term, but I have no idea what that means. What does that mean, young lady? What is a situationship? Is that like an entanglement? I don't know. Huh? Okay, but you all had a situationship. Okay, how long?
Probably like 6 months.
6 months? Okay. All right. And, but you all have had no contact since this happened? Okay. And you intend to not have any contact?
I move forward.
You move forward. All right. And you're not asking for any restitution or anything like that? All right. Anything else you'd like to say?
No.
All right. Thank you very much. All right. Ms. Dukes, is there anything you'd like to say before I pass sentence? I'm sorry? Yes. Well, you make sure you speak loud enough so she can hear you.
Okay. I'm really sorry. I said it before, but I'm really sorry. to know.
Okay. All right. The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact not only on Ms. McCarter, but also on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors as set forth in revised code 2929.12. Accordingly, Ms. Dukes, I hereby sentence you to a term of 2 years community control. I want to do intensive supervision, but I want to do the mental health docket because I want her to, so it might just be NDO because I want her to get evaluated for whether or not she needs assistance with medication and treatment. There will be court costs. There will be no fine. 0 restitution is requested. There will be a stay away from Ms. McCarter. If you violate the conditions of this term of probation, I will not hesitate to sentence you to a term of 18 months, up to 18 months in the Ohio Department of Corrections. Do you understand? All right. And so is there anything else, counsel? State?
No, Judge, thank you.
All right. You have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand that? Now, I understand that you have a nursing, you're getting ready to get your nursing degree?
No, it's my PCA.
PCA.
It's my PCA license, yes. I completed the entire course, but I didn't complete the final test. Will be able to affect my ability to work at the.
How will this conviction affect that?
I was led to believe that they don't hire felons as soon.
Yeah. All right. Well, you'll need to go over probation right after court, and we're going to send the paperwork ahead of you so you won't have to wait. All right. All right. All right. Anything else? Thank you. Thank you. Cost 0 fine. I think I'm getting old because I don't know the difference between a situationship, entanglement, and a relationship. I need to ask my young nieces and nephews. I don't know what that is. I'm getting old. Okay. Ms. Marinakis? Huh?
I don't think she knew what it was.
All right. This is the matter of State of Ohio versus Ryan Hankins, case number B2601465. Mr. Hankins is present in the courtroom with his attorney, Ms. Marinakis, and Mr. Croswell for the State of Ohio. This matter is set for a jury trial today, Ms. Marinakis. I see that you filed a motion to continue. Would you like to speak to that?
Your Honor, we were last seen, I believe, May 21st, and I told the court I had 2 trials set last week. One at the last minute fled, but the other one went. So I'm just not as prepared as I would like to be able to move forward this morning, so we're asking for the continuance.
All right, thank you very much. State?
No, state's ready to proceed, Your Honor.
Okay. Well, I think for good cause. Mr. Hankins, did you know your attorney was going to ask for this continuance? Oh. But before you came to the court?
Yes, and I didn't even know I was going to the trial.
Judge, she was here for the pre-trial, so I don't know why there's confusion.
All right. All right, so for good cause, I'm going to grant the motion to continue. That's the first thing. And we need to pick a new date. I see that there's a speedy trial waiver. And I'll go over that with Mr. Hankins in just a moment. So, Ms. Howard, let's try to get a new date for Mr. Hankins. So he's been in custody 84 days, looks like. Yeah. No. July 7th, is that?
Judge, I believe I'm out that week. The court doesn't have anything available in June?
No. We're actually out till, what, October, but because he's in custody. Ms. Marinakis, does your client want to have a jury trial or a bench trial?
At this point, we only talked about a jury trial. Court decide.
We can always further talk about that if you want.
Judge, he's willing to make a bench trial. Is the court available for that in June at any point?
I don't know. Ms. Howard, would you look for that? So all right, so there's a bench trial waiver, a jury trial waiver in the, I'm sorry, there's a 2-drawer file cabinet right there, Ms. Marinakis. All right, do you want to talk to him there, or do you want to talk to him over here? I just don't want to have some privacy.
Right there, Judge, I forgot the mic's on here.
Yeah. Yeah, you can, yeah. Ms. Ross is ready? You finally ready?
Well,
Oh, you still?
I talked to my PWs are out there. I talked to them real quick and then.
Okay, well, we finish this, we'll go ahead and let you do that. Ms. Howard, I'll be asking for a date in a minute.
I'm looking at 624, Judge.
Okay. What if she can't do it then? Because we got a motion to suppress that day. Oh, okay.
Your Honor, we're going to stick with the jury trial at this point. If things should change, I can always come back.
Okay, we had a date for you. Okay. Well, she's gonna work that. In the meantime, let me go ahead and address this. So, Mr. Hankins, I have in my hand a single-page document. It's called entitled "Defendant's Waiver of Speedy Trial." I see there's signatures at the bottom. I recognize Ms. Marinakis's signature here, but right above, is that where you signed it, sir? Okay. Did you hear that? Okay. And this is an acknowledgement by you that you understand that you have a constitutional right to have your case resolved in a certain amount of time under the U.S. Constitution. You have a constitutional right for that. But because your attorney did request a continuance due to her schedule, and because she wants to be fully prepared to represent you and defend you in a case, she's asked for that continuance. And are you in agreement with that? All right. And so did you understand what you were signing, that you were basically saying, I understand my right under the Constitution to have my case resolved in a certain amount of time, but I am willing to extend it and continue it so that my attorney can be prepared. Is that your understanding? All right. I will accept this defendant's waiver of speedy trial. Ms. Howard, can we get another date as soon as possible?
We're looking at June 15th.
June 15th. Oh, that's soon. Okay. Okay. All right, so she can work her magic, Ms. Howard worked her magic to get June 15th. I don't know how she did that, but that's only 14 days from now.
Judge, should be plenty of time.
Okay, Mr. Hankins, are you good with that date for a jury trial? And you understand it's a jury trial, right? Because I know you came here today, so I didn't even know it was set for trial. You understand now it is set for trial and you're in agreement for that date? Okay. All right. So we will go ahead and continue your matter and set it for a jury trial. Let me ask the state, is that enough time to get your witnesses here?
Yeah,
Okay.
thank you.
All right. June 15th, 2026 at 10 a.m. All right. I don't think we need to set another final pretrial conference because we had that already. Do you anticipate any evidentiary issues coming up before the trial date? All right. If Mr. Hankins wants to resolve his matter short of a jury trial, I'll take the plea on that day. Okay?
Yes, ma'am.
But you guys just let me know. All right. Anything else?
Judge, we had filed a motion to reduce bond, which the court heard on May 21st. Mr. Hankins is asking the court to please reconsider that bond. Again, I know the court remembers that he has medical issues, he has sickle cell, he has made 2 runs to the hospital, one of which I know involved a stay for a number of days. His mom is with us this morning. She indicates that she got a phone call from the Justice Center that her son was in extreme pain, and it's just very hard having this condition. I know the court's aware, and being in the Justice Center is never easy. It's my understanding that Mr. Hankins has a stable place to reside. I think he's going to stay with his mom, is that right? He will be staying with his mom. I know there were some failures to appear, but I think what would remedy that is if the court would have placed him on EMD. That way everyone would know where he is. We only have limited hours out, and we're just asking you to reconsider it this morning.
State.
I said motion be denied, Your Honor. I don't see any change in circumstance in the last 2 weeks or so since the last time was heard. He does have 4 prior felony convictions for drugs.
Yeah.
I'm very sympathetic to his diagnosis of sickle cell because I understand it involves a lot of pain and suffering. I'm very sympathetic to that. But the court reviewed his record last time. And that's why we set the date so soon for a jury trial to resolve his matter. I agree. I don't think there's been a change in circumstances, although, you know, his physical condition in the Justice Center is definitely not ideal. I'm glad we only have 14 days between now and the next date, which is very rare. I don't know how Ms. Howard did that. It's very rare to get a trial date in 14 days, but I'm going to leave the bond set at $25,000 at 10% plus EMD, and we'll see you back here on the 15th.
Thank you, Your Honor.
All right, where are we? We got, those ladies sitting right there, are they probation officers? Are you all probation officers?
Yes.
Okay, who are you here for?
Tina Miller.
Okay, we're ready on Tina Miller. Is Mr. Kathman out there for Tina Miller?
No, but he said he'd be back in 5 minutes.
Okay. I didn't realize the officers were here for them.
I'll text him later.
Yeah, no, we're ready. Tina Miller.
Mr. Church, you got Mr. Church up there?
Yep.
Just back to motion.
And Ms. Roth, you're waiting on the prosecutor to make a decision about something?
Yes, ma'am.
Okay. All right, sorry for the long wait. Did they figure out what's happening to our sound system? Oh, wow. Okay. Never mind.
It has so many issues.
Because these are not the right ones.
know.
This is like for a conference
And I
room,
remember you telling me that.
not for a big courtroom that bounces. You cannot hear.
It's ridiculous. This one, when people speak on the podium, I mean, the sound is dancing all around my head, but it's like I can't catch the sound. Even
Wow.
with the headphones on, I can hear your speaker better than I can the podium. And then sometimes, depending on how far away they stand, it's the same as the podium. You can't hear it. It's echoing.
See if
I'm like, what is that?
Tom Barragon can come down here. He needs to hear this because this is not good.
And I noticed some of the other reporters are having trouble.
They are,
Yeah,
because
same
they're not the
issues.
right, they're not the right system.
It's ridiculous.
These are supposed to be department economics.
Yes. And then they got a nice big fat contract field.
Mm-hmm.
That's a lot of money. I'm like, what are we doing? So,
I don't know what we're doing. It's, I have no idea.
I mean, they should have asked the reporters first.
Should have.
The judges and the reporters need to hear.
Especially for these rooms,
Yes.
you know, I mean,
Yes.
maybe it's different in 485 or 585.
The rooms with the lower ceilings, you can hear beautifully.
Yeah,
those
but in
rooms.
this room, it's
This
an
is-
echo, it's just,
They need to fix it. 'Cause that's a
and I
problem.
think, yeah, and I think that the folks that actually set the system in,
Mhm.
I think they need to be here when it's court, so they
Yes.
can hear.
Yes.
Because when no one's here, I don't think they're able to hear it the way we hear it.
And for a reporter, that's kryptonite. Can't
Mhm,
hear.
mhm.
It's like, what?
It makes your job so much harder,
Man, I'm struggling sometimes. When
and that's not right.
like today, there was no audio, so I could hear beautifully. That's weird.
You can hear better without this
Without-
audio.
Without. I'm thinking, what is happening? Well, like you said, conference room,
Mm-hmm.
because the sound was just dancing all around.
Yeah.
If I didn't understand the lingo in here, I'd be totally messed up. So if there was a new reporter sitting in here, she'd be like.
It'd be difficult.
terrified.
Yeah. All right, we're waiting on,
Just text Mr. Jackson to come back and Mr. Catherine come back.
Mr. Kathman has the sentencing. Mr. Jackson has Mr. Phillips.
Yep.
And then Ms. Roth is here. She's been here all day.
And I saw Miss Winston, she was in here for church.
Magistrate Paradise.
Did she change her shampoo? Did she go back?
Yeah, but it's still, yeah. I
Did she
think
have
it's,
something to treat it?
I think it's, that's not the only thing I can think of.
I know.
That's what I'm thinking.
Is it black? Do you use?
It's dark brown.
Is it a rinse or? Because the rinses, I can't use them.
Here. Our sound is really, we're having so much difficulties. I wanted Hope to tell you.
Okay.
Because has anyone ever told you guys that, or told you that these are really for conference rooms?
Well, so you're gonna get a wired gooseneck on your bench. You're gonna get a wired gooseneck for the witness too.
Okay.
So you've got that. You still have the big ones for the podiums but your podium needs to have, which of course it doesn't, it needs to have a plexiglass riser on it that brings it up. So it isn't flat down like that, but it's raised up and tilted down. So it's,
You mean this?
so we can actually have the speaker. Yours needs to be the gooseneck. We've already bought the goosenecks. We just have to get the wires put in. So
Okay.
we'll have those there. We're gonna switch these out coming actually this week. We got them yesterday or Friday, so there'll be a gooseneck there. You just don't have a
Gooseneck
wire.
there.
You don't have a wire yet for yours. Or should have.
Okay, because,
Have you talked to Judge Hathaway?
And we're getting her. We originally DeBross said that her speakers in the ceiling would work. They don't. She's getting the ones that you're getting there.
Because I know her reporter and Judge Branch's reporter were having the same issue.
We worked with Judge Branch last week to get her set up, and she had a full training. And I'll have Bradley come in and give you a training about how to use that bench too. So I'll make sure that gets done. But
So
yeah, these are going away for the bench. They
Okay.
just don't work.
they don't work anywhere. Like right now, that one's not working at all today. Bradley's aware
Okay.
for the prosecutor. It's not working at all.
Yeah.
So he's just having to talk. And then we can't really hear from.
The tables. Yeah. So
Well, so from, not from the table, from the podium.
Yeah.
So when the people at the podium speak, she cannot hear.
It goes,
So we're gonna. Yeah. And
even with the headphones, I can't.
that's what it should be able to headphones. You need to get the Grace thing up there. Or if I need to get a wireless gooseneck for the room, or get a wireless gooseneck, so I know to speak into it. But I appreciate you letting me know.
Okay.
These are things I need to hear.
Okay.
Okay. Hope I'm sorry. We'll get Bradley down to work with you on the box so we can get that set up. The other thing is we just hired, this is a problem, we just hired actually a sound engineer to come in and be able to adjust the levels, work with the different microphones and the speakers so that when you talk with that and it gets to the gooseneck, it won't be 80% on that
Yeah.
speaker. Back there, it'll be 80%. So they'll hear you better from there. Same with this. They won't get the echo from there. but it'll be louder out there. And he's also going to adjust all the speakers so they're pointing the right way.
And I know that they would prefer to be here in the evening when no one's here, but they need to be here when like during court.
So we've actually switched it around now too. So we have the BIS technical guys and DeBron during the day, during the last week of installation.
Good.
So that the judge can hear it, you can hear it while we set it. Yes. I'll get them in next time they're here to adjust this. But our sound guy is actually, you're on the list. I'll make sure you're number one right now to get in and get your stuff adjusted. Are you going up to the conference?
Yeah.
Okay, so you'll give us some time during the week too to get in here as well. Okay.
Yeah, we just been having a hard time, and we got a lot of trials this summer.
I know, and I want to have everybody's up and running for summer. My hope is the sound guy, by adjusting the speaker levels and the microphone levels, is going to make it a lot less echoey
Yeah.
and a lot direct, but we'll also get yours tied in so that we can hear that. Yeah, because right now, I guess it's even loose for the speakers around, so they're pointing in different areas. And so you can hear well, but also the gallery can hear, and the witness can hear.
I mean, because, it's one thing if I can't hear, but if she can't hear,
Oh, I know. Oh,
it's a
yeah.
problem.
Oh, I trust me. I know, and this is,
And so today, like without any speakers,
Yeah.
people just talking
I know.
regular, it's better for her.
oh, I know, and that's, I know, that's not normal, so. Thank you. Yeah, well, maybe this week, when Beach comes in, I'll have them stock out, I'll have them probably come in. Okay.
All right, thank you.
Thank you.
This is the matter of State of Ohio versus Tasha Stevenson, case number B 2506639. Ms. Stevenson is present in the courtroom with her attorney, Ms. Monica Roth, and Mr. Nick Croswell is present for the State of Ohio. This matter is on for a jury trial today. Counsel, are we ready for a jury trial?
Judge, we've been waiting for an outstanding video. The court was alerted to that matter some time ago. We waited last week, it was to be dropped off, it wasn't. He has it today, if he'd like to send it to me. I do need time to review that video, it was from the same day, it looks like.
All right. State?
Yes, correct, Your Honor. We are now, state's now in custody of that video. Prosecuting witness indicated she was trying to bring it down last week, but a medical situation arose with her son, and she was unable to bring it down to us. We do have that now. Now I would try to figure out how to get it uploaded and get a copy of it with Ms. Roth as soon as possible.
All right. So we need to continue the trial date. So defense is making an oral motion?
Yes, Judge.
All right.
I move to continue the trial for those reasons.
All right. Any objection from the state?
No, no.
All right. So oral motion by defense is granted. No objection by the state. Can we go ahead and get a date, Ms. Howard? Now, Ms. Roth, I'll tell you, we're probably in when, July or August? July 7th is the only date in July, and then August, we'd have to put it in August.
Did you say 7?
Is July 7th work for you guys? Is that good date?
July 7th? Does that work?
Yes, Judge.
All right, so we'll set this for a jury trial, July 7th, 10 a.m. Time waived until then?
Yes, Judge.
All right, is there anything else we need to discuss at this time,
Yes, please.
Ms. Roth?
I did attempt to file a motion on Friday. I don't know the status of that, whether it was accepted or not, but the state did know I wanted to address in terms of her part today.
Oh.
Prosecuting witnesses are present.
Let's see. Yes, it's here. All right, look, did you get a copy of that, Mr.?
Yes.
I don't have a copy in my file.
Yes, I did see it.
Oh, my goodness. All right, so you need a copy, Mr.?
No, that's a copy.
All right. Well, I do need a copy. What would you like to say on behalf of Ms. Stevenson, Ms. Roth?
Judge, as the court is aware, she's followed all of the rules of bond, even when it was super difficult to do so, when she had to live away from her house for some months. The court did allow her to move back to her house. The EMU unit is still very difficult with her employment, etc. She has not violated in any way. She has no desire to interact with the prosecuting witnesses and has done a great job staying away from them. I just asked the court to consider removing that ankle monitor, as this continuance is not her fault. It is the fact that we were missing a video. So I'd ask the court to take that all into consideration.
All right, State?
Could I have 1 second, Judge?
Sure.
Prosecutor.
Absolutely.
We did vote like to address the court regarding that situation.
All right, well, can you step to the side? Can you step to the side just for a second?
She has.
Wait.
I'm sorry.
Step up to the mic. All right, what is your name?
My name is Dorothea Young.
Miss Young?
Yes.
All right, what would you like to say, ma'am?
So she has definitely still been in violation. She has reached out to a mutual friend of mine, which is a blood cousin of my girlfriend, Rhonda Price, to basically bribe us. She wants to offer us money to get her off this charge, literally.
Has anyone contacted you about
Yes,
it?
he walked up on me while I was at work on Thursday at the Kroger building, because I do pop-up shops, I'm an entrepreneur. So, he walked up on me telling me to ignore whatever was going on with this case. That's how he initially said it. He said, ignore so-and-so, so-and-so. I'm like, what? I don't talk to anybody about, what I have going on. He broke down how he knows Miss Stevenson, and he said that she wanted to reach out to him to get us to see if she can give us money to get her off of this. But see, the issue with this is we have already multiple times, just tried to diffuse stuff, and we don't know her. So that's she's really a threat to us. So we don't want her near us. We don't want her, if it's hard for her to get home, she should have thought about these things before she made the decision that she made. She literally put our entire lives in danger, our children. At church, she made it to where we can't go to church and be safe because she walked into a church and did what she did. So we don't.
This happened in your church?
This happened at our church.
Okay.
This incident of why we're here happened at our church. She's violent. We don't.
What church you attend? Or used to?
It's First Shiloh. It's in Avondale, South.
Yeah. All right. Well, thank you very much, Ms. Young. I appreciate it. All right. There's two victims.
Yeah, Ms. Price is here as well. She indicates that she was fine with Ms. Young's statements, and it kind of echoes that request that the motion be denied.
Okay, so two victims and they're both here, so we comply with Marcy's law?
Yes, Judge.
Okay. Now, my understanding is that Ms. Stevenson and Ms. Young and what's the other victim's name?
Ms. Price.
Ms. Price, they all live in the same neighborhood?
They live close to each other.
Close to each other, okay. And Ms. Stevenson wants the EMD off because what? I know it's inconvenient.
It is, Judge. It has caused her to not want to seek additional employment because of the physical box that's on her ankle. If I could, just briefly, she does deny sending some man to talk to them. People do what they do on their own. I don't know why they're saying they don't know each other. She was the victim of an assault with this young lady being the defendant at one point prior to this.
With Ms. Young?
Yes.
Okay.
So the point is, she has stayed away. She will stay away. Zero problems. She's compliant. And I'll say that.
Okay. So there was a prior incident where Ms. Stevenson was the victim?
Correct.
And Ms. Young was the defendant?
Yes.
Was that last year?
2023, November the 30th, they came to my job.
Okay, I want to, that was 2023?
Yes.
Okay. So Ms. Young, you said y'all don't know each other.
We don't know her. That incident was from her, again, harassing us. She worked.
Okay, I'm saying, okay, I understand. When you said we don't know her, I thought you just didn't know her until this
We
incident.
don't know her, it's like, we don't have any relations, like, all
I
of
see.
this resolves it from her harassing us.
All right, thank you.
Literally. Like, it has nothing, in that case, that incident had nothing to do with what she walked into the church and did.
All right, thank you. So there is history here, I see. All right. At this time, I think for the safety of everybody, not only Ms. Young, Ms. Price, their family, but also for Ms. Stevenson and her family, I think it's better, more prudent to keep the bond situation as is. So motion to modify the bond is denied. We will come back on July 7th and try this case and get this case done so that we'll have a resolution for everybody involved, okay? All right, we'll see you then. Mr. Jax, no, I'm ready for Ms. Sentencing on Tina Miller. Where's Mr. Captain? There he is. Oh, I thought you're sitting over there.
He's playing Candy Crush.
All right, this is the matter. These are the matters of State of Ohio versus Tina Miller. Case numbers B2405987A and B2505775. Ms. Miller is present in the courtroom. With her attorney, Mr. Ed Kathman, and Mr. Nick Croswell for the state of Ohio, and Ms. Jennifer Kelly is present on behalf of probation. We're here for sentencing today, sentencing on the probation violation, the B2405987, which has really just been, tagging along with the new case, which is B2505775. On that case, Ms. Miller entered a guilty plea to count 1, trafficking in cocaine, a felony of the 3rd degree, on April 27, 2026. The court accepted that plea, dismissed count 2, and we set this over for sentencing because it was my understanding at the time that Ms. Miller had a Muni Court OVI case that was set for sentencing, and we wanted to get that case resolved before we went on with this one. I did not feel the need to get a PSI because she has been on probation to me already. And so we're here today. Are you ready to proceed today, Mr. Kathman?
Yes, sir.
All right. Mr. Croswell?
Yes,
Okay, thank you. And Ms. Kelly, are you ready to proceed? All right, thank you very much. Mr. Kathman, what would you like to say on behalf of Ms. Miller?
Thank you, Your Honor. I did have opportunity to speak to Ms. Kelly this morning about probation and what's been going on with Ms. Miller, and I think it kind of coincides with what we discussed when we were here in the plea. Just to back up a little bit, the OBI was reduced to a reckless, so she was put on probation for that. She has to do the 3-day program, and she hasn't scheduled yet, not because of today.
Okay.
It's going to go on today, so that's something that she's going to have to do. But that was a good resolution. When we were here for sentencing, we were not offered to plead to the possession. I did believe that this case should have been a possession, but it just seemed silly when they were the same level of charge to go through a trial just to get a possession instead of trafficking. When you look at the facts, it was a search by the probation department. They came in and they made the conclusion that it was possession and trafficking because there was a scale there. There wasn't money, a bunch of money. There wasn't, they didn't go through a phone and say, hey, we're seeing evidence of trafficking. None of that. That kind of coincides with what the issue has been in this case. She's from time to time has tested positive, and I don't believe that she traffics at all. I mean, she has a business. She works full time. She doesn't need to do any of that, and obviously, it's not a good course of conduct to engage in. She uses, and from time to time uses, and sometimes she uses more than other times, sometimes she doesn't use at all, but that's the issue here, and I think that's been the issue from day one. Judge, I'm not really sure which way the court is leaning on this. I think Ms. Miller has more to offer than a lot of people in society, and I think that this is a situation we need to address. I just don't believe it needs to be addressed at Marysville. I think she can make the corrections. If she's a danger to anybody in society, it might be herself. I don't think it's anybody else. Seems like I said, she does work and she does provide for her family. She does help out with her mother who's ill. We discussed that when we were here last time. And I didn't get the impression that she was the scourge of the probation office. Although, what we're going to discuss here shortly, speaks for itself, I'm sure. So I'd ask you just consider some type of sentence that it has some treatment involved in it, however the court feels is appropriate. And I still believe she needs to serve a sentence in the Department of Corrections. It's something she might need some help getting a handle on, and then she can be even more productive than she is. So that's all we have, Your Honor. Thank you.
All right, thank you very much. State?
Oh, you're right. She's on probation to you for drugs as well as a weapons charge. It picks up new trafficking cocaine while on probation. And the drugs were found at least partially in a drawer. And it also included a bunch of sandwich baggies, digital scale. So that was the addition of trafficking. If it's personal use, you don't have a bunch of sandwich bags sitting right next to the cocaine. I'm not sure if probation has to add, but I don't believe she's a good candidate for probation, considering she's on probation due for the same thing. It picks up new charges on probation.
All right, thank you. Ms. Kelly, is there anything you'd like to say?
Just for the record, Ms. Miller did come see me after the last time we met. I had to do a drug screen. She did come back positive for cocaine. During that office visit, she said that she does need help with this addiction. I referred her to the council of the CAT House, the addiction services. And she's been telling me she's been going, but I have not received anything showing proof that she's getting treatment. Even today, I continue to keep checking my phone, see if I'm going to get an email. I reached out to a contact that I had at the CAT. I have not heard back from them, so I don't know if she's getting treatment or not.
All right, thank you very much. Ms. Miller, is there anything you'd like to say before I pass sentence?
I did the assessment and everything. My mom had surgery. Her cancer spread through her nose, so I was helping with her. So I did the assessments and stuff like that, but I don't know why they didn't email her. I told them to, but I did do the assessment. I did take those steps to do that.
All right, so I'm sorry to hear about your mom. So you did the assessment, but you didn't get any treatment?
Yeah, I was in the process of doing all that, but my mom just had surgery again. This is her second surgery.
I see. All right. Anything else, ma'am?
I apologize, and I hope you give me another opportunity. And I won't mess this up.
Well, you said that May 7th, 2025, when I sentenced you the first time to probation, and 5 months later, you were back on a new charge. This is concerning to me, obviously. The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors as set forth in revised code 2929.12. Accordingly, Ms. Miller, as to the probation violation case B 2405987, I hereby sentence you on count 3 to 12 months. First of all, I'm terminating your community control in that matter. I hereby sentence you on count 3 and 5 to 12 months in the Ohio Department of Corrections with 14 days jail time credit. Those counts to run concurrent with one another for a total term of 12 months in the Ohio Department of Corrections. Costs and fines remitted. Upon your release from prison, you may be on post-release control for up to 2 years. With regard to the new case, B 2505775, I hereby sentence you to a term of 12 months in the Ohio Department of Corrections with credit for 10 days jail time credit. You will pay court costs, fines remitted. Upon your release from prison, you may be on post-release control for up to 2 years. This case and your other case, both cases to run consecutive to one another for a total term of 24 months in the Ohio Department of Corrections. And anything else, counsel?
Judge, would you consider a stay? I mean, I know that she's had a lot going on. I know you hear this a lot, but if you could consider a stay on this, so she can just make sure that the mother and everything else is taken care of.
State anything on that request?
1 second, Judge. Sorry, Mr. Judge, I was trying to look through to see her bond sheet, see if any failure to appear or anything like that. I did not see that in my paperwork, but I would defer to.
I don't see any of that. My concern here is that while on probation, she picked up a new charge. And then while the new charge was pending and the probation violation was pending, she picked up another charge in municipal court. I'm very concerned. I want Ms. Miller to be safe. This stay is denied. You may have a seat over here, Ms. Miller. You have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Anything else, counsel? State? Thank you very much, everyone.
Yes.
Did you get the certificate? Did you hear everything? Did you hear everything? Okay. All right. Did you call somebody?
Yes.
They went between people, they wanted him to take her back. You were able to stand before you said again. And they gotta find somebody.
All right, this is the matter of State of Ohio versus Isaiah Church, case number B2500241. Mr. Church is present in the courtroom with his attorneys, Ms. Darcy Winston and Mr. James Moore. And Mr. John Rendering is present on behalf of the State of Ohio. This matter is on for a status report. We have a trial date at the end of this month, June 29th. Let me first ask counsel, is that still a viable trial date?
For the state, yes.
All right, excellent, because we have worked very diligently to try to find that date and try to protect that date.
Yes, sir.
So June 29th is the date. All right. Now, I have a motion for in-chambers review, and then I also have some motions in limine. Didn't know if you guys wanted to be heard on the motions in limine today, or do you want me to just rule on them? You submit?
I think the hope was, at least for the newest motion, that we would schedule that for a hearing date. I wasn't prepared to address the motions in limine today. I was waiting for the court's direction to indicate when we wanted to address those. So,
All right.
sorry.
So you want a motions hearing for all of them?
Yes, Your Honor. And then if I could just add, we filed those motions, the Friday before our last trial setting that we asked for the continuance.
Yes.
So, realistically, I don't think we'd be amending them, but I think the motions hearing date would just solve everything.
All right. I was just trying to resolve it to give you guys some parameters as you prepare. So let's just get a hearing, maybe 30 minutes on the motions, all the motions.
Yes, Judge, so while we're scheduling that, I think it's probably a good time to bring up that we have filed a motion for in-chambers review of material that would be submitted pursuant to 290702D. We certainly intend to give everyone a detailed explanation of what we're talking about, just not on the record today.
Yeah, understood. All right. Well, let's get a date for the motions hearing then. Ms. Howard, we're going to need 30 minutes somewhere before June 29th, 28 days, which our calendar is jam-packed, but we'll figure it out.
The lightest date we have is June 18th, but you can open it off for yours, and it's because there's 2 hearings in the morning. I don't know if you can do something in the afternoon.
No. I do have a note. Do I have a note on here? I thought I had it. Yeah, I thought I had a note on there.
We may be able to do it. The 24th, we would have to be afternoon. And that's just a job, you know.
You can try next Monday afternoon. Monday afternoon. Yeah, I'm thinking, I don't know if these cases are going, I don't think one of them is gonna go. I don't think Ms. Vanderhoff is going. Let's see, the other one might go, we'll see, but I'll just have to work around it. Yeah, but I think Ms. Johnson has already indicated she's going, so. Why don't we set it at, let's see, all this 10, and then we'll get ready for the jury. Why don't we set it at 1 o'clock on next Monday?
Your Honor, sorry. For the record, I might be in jury trial, but Mr. Moore can be here.
Okay, all right. Next, I might be in jury trial too. So, but, all right, so let's set it for, does that work for you, Mr. Rendering?
It does, thank you, Your Honor.
Let's do June 8th, 1 o'clock. And we'll just take about 30 minutes and resolve these motions, okay?
Yes, sir.
All right. None of the motions require any evidence to be put on, just argument from counsel, right?
I think so.
So the motion for in-chambers is just
Well, right, we'll submit something to the court to opposing counsel that will explain in detail what we're talking about. I don't think we have to go on the record. And it's say, this is what it is, you need to read it and see what we're talking about.
Okay, it's something that can be read that day.
Yes.
Okay, all right. Well, we'll do motions hearing on this case next Monday at 1 p.m. Thank you. All right. Oh, Phillips. Okay. Got to be here on Phillips. That's the last one, right? Okay. Yep. All right. These are the matters of State of Ohio versus Antonio Phillips. Case numbers B 240-2042, B 240-4562, and B 240-2711. Mr. Phillips is in the courtroom, waiting patiently since 9:30. And with his attorney, Mr. Jesse Jackson, Mr. Nick Croswell is here on behalf of the state of Ohio, and Ms. Lauren Timon is present on behalf of the Adult Probation Department. These matters are on for a new cited probation violation, and then the other cases are, well, all of them are for cited probation violations. So, counsel, do you have a copy of the community control sanction violation report?
Yes, I do.
All right, and State, do you have?
Yes.
All right. Would you like to, your client like to have a probable cause hearing on these matters? All right. May I hear a statement of fact?
You are on probation team, 3 different case numbers. The violation is that you picked up new charges, an obstruction charge downstairs, as well as driving without a license. I'm not sure what the status of those at this point. He was set for trial last month.
All right, thank you very much. Counsel?
I can report to the court that those cases, those matters have been resolved in municipal court. Mr. Carl Rules represented Mr. Phillips in those cases before the Mallory.
So they've been resolved, not dismissed?
They've been resolved.
All right. Hmm?
They were resolved with the plea.
All right, thank you. So these are all violations because of the new charges in municipal court. How does your client plead to the violations? All right, Mr. Phillips, is that what you want to do today to resolve your probation violation cases? So what is your plea? All right. A guilty plea on the probation violations in each of these cases is accepted, and there's a finding of guilt made on all three probation violations. Counsel, what would you like to say on behalf of, would you want to proceed with sentencing today?
Judge, we can set it up for Mr. Phillips. Mr. Phillips has some things that he's still in the process of trying to resolve regarding his license.
Okay.
So we'll come back in a few weeks for sentencing. There's also some information I have to gather regarding his employment situation. I wasn't able to get before today because I was out of town with something in San Diego.
All right, probation, with regard to this continuance, do you have any input on that? Okay. Well, I'm looking at the recommendation on, he has been found guilty of these probation violations, so I'm seeing the recommendation. I'm concerned, Mr. Phillips, about your conduct that has caused you to violate probation. First of all, you have 3 cases on probation. And that tells me that I've been giving you some chances. And then you picked up some new cases in municipal court. And I know at sentencing, your attorney's gonna ask me to give you some more chances. But I'm gonna tell you right now, I'm very concerned about you picking up new charges. Don't say anything. Don't say anything. Was he convicted of the obstructing official business?
It's my understanding that he pled times.
He what?
He pled guilty to the sentence.
Okay. And then he was found guilty of driving without a license. And you want some time to allow him to get his license squared away?
His license squared away, Judge, and there's also some issues with employment. I know that probation has concerns about Mr. Phillips getting employment, and Mr. Phillips presented some information this morning. I was able to do some information this morning on his phone, but I'd like to obtain copies, hard copies of those documents that will show up to the state and also to the court.
All right, looks like the driving without license was dismissed. That was dismissed. What does it say? Judge's notes, Judge Dwayne Mallory.
That's a plus in our contract.
And then, yeah, that's the case I'm looking at. And then, he was convicted of the obstructing official business. Nevertheless, still concerned, young man. Okay, I'm gonna give you some time to do that. What I'm gonna do is continue these. Well, so is he getting ready to get a job? Is that what he's doing?
I can report to the court that I was able to use a certificate. He's established a company name, delivery auto detail, registered in the state of Ohio.
You gotta talk up a little louder because we're having a hard time with our.
He's registered a business with the state of Ohio.
Oh, he's gonna be an entrepreneur?
He is. What the friend of his or his relative, if I'm not mistaken. So all those details, I need to nail down those details exactly to be able to present to the court in an articulate fashion. But I was able to see the certificate from the state of Ohio, Frank Lewis's website.
Well, that's great, but he needs a job where I'm excited that he is seeking to be an entrepreneur, but he needs a job with some taxes and wages and like now.
So here's my plan for that. What I've done is what I haven't done yet is plan to connect Mr. Phillips to a Tower House program that has employment opportunities for fellows from the defendants to get him engaged in a job that can pay not only a good wage for him, but perhaps get him some health insurance as well, which is important. So I think that give him a couple of weeks, maybe 3 weeks, and then we'll come back.
Has he ever worked while he's been on probation?
I only saw him a few times since he was discharged from River City and was not employed at the time.
When was that?
When was that? He entered River City after being violated on probation on September 18, 2025. He entered September 22nd, 2025, and was discharged February 26th, 2026.
That's right.
Okay.
Subsequent to the River City program, he was engaged in attending the River City Aftercare program through cognitive behavioral intervention classes.
Is the River City Aftercare completed?
Yes, he
Okay.
graduated from the River City Aftercare.
He graduated. Okay.
So there are a lot of positives. We just need to work on the negatives.
Yeah. All right. I'll continue for sentencing. Let's probation is requesting that I put him on EMU though.
Judge, I'm not following the EMU recommendation. Mr. Phillips has kept in good contact with me. I didn't see anything in his record of background. Maybe the court can enlighten me that he failed to appear to court at any time he was requested to do so. So it does take up to 90 days. I'm just not understanding at this point what the EMU recommendation is hoping to accomplish. I mean, he's stayed in constant contact with me. He's been in court 2 hours today, waiting patiently on me, the documents finished. So that's my standpoint at this point.
All right. Well, I'm gonna give you time to talk to probation and all of that, and we're gonna come back for sentencing in 30 days. And when he comes back, I want him to have some employment and no new charges. Okay? Is how?
Wednesday, July 1st.
Oh, Wednesday, July 1st. Did he want to say something? Okay. He's not happy. Oh, I know it's hard, but you gotta find one. Just because it's hard, I mean, you can't, I'm letting you off the hook.
Judge, I am out from the 1st of July to the 6th. I need before or after.
Okay, July 1st does not work for the council.
Are we looking for a time before the 1st?
Either one, before or after the 6th. Before the 1st, after the 6th.
You said before
Before the 1st or after the 6th.
after the 6th.
If it's a Monday this hour, I can do it on the 29th, but I have a 10 o'clock in June. So June.
We can do Wednesday, July 8th.
I can do that.
Okay, Wednesday, July 8th?
Yes.
All right, that gives him a little bit more time to try to find something. Also, he can go to the Office of Reentry. Go right over there. Tell them I sent you. They can help you find a job. Your lawyer will tell you. Just tell them that, what'd you say?
I say yes and no.
I'll just tell, when you get over there, just tell them Judge Cross sent me. They know what that means. No. Office of Reentry. It's when you go out the courthouse, it's right, you should go walk straight across the street, and it's in that building on Court Street, right before you get to Kroger. You know where Kroger is? Right before you get to Kroger, you're going to turn right into the building, right there across the street, Office of Reentry. I just left court. Judge Cross sent me. I need a job. Okay? All right. We'll see you back here July 8th at 9 a.m. Thank you. 9:30. I'm sorry, 9:30. Yeah, sorry about that. 9:30. Is that a Monday? 9:30? Um, 9:30. All right. Thank you, Mr. Croswell.
These are shred things, I did can't say it. Shred things. Thank you, man. See you guys tomorrow.
All right. Well, wait. Do we have anything tomorrow? Yes, we do.
You got your little stuff.
Yeah, we just got I just put it on there. Yeah. And then the rest of the week I'm at
No, I never, right?
and then the
I ain't lucky.
rest of the week I'm at a conference.
That's all right, I understand.
Okay,
Good luck.
thank you.
Thank you.
All right, see you tomorrow. Hey, Laura, would you mind turning this? That concludes the docket.
My son recently got married.
No, congratulations.
You said you were in San Diego. Where did you get married? I know that's a beautiful venue. You said your son's in San Diego?
In San Diego. He was in the military up there.
I was gonna say, what's your brand?
My Army, 12 years.
Okay, 'cause both my sons are out there, they're both Navy.
You know what? He was out there for 12 years. I never visited. Went out
Oh,
there.
man.
I went out there for his wedding and absolutely loved it.
I know, it's a tough act to follow. My husband said you were there.
Yeah, that took judge when you get done.
Nice. Well, he's older than my son, so I won't say they know each other. He's in
Yeah, he's, he look at him my age. He's 38.
Nice. He's the same age as my son.
Oh, that's a nice picture.
Where'd you
Very
get
nice
married?
picture.
Sunset Beach.
Oh, nice.
Oh.
Sunset Cliffs.
Sunset Cliffs, yes.
Awesome.
Do you know what it is?
Yeah, we lived there 20 years.
There was a home over there. I can't afford it, but the judge.
Oh, man.
No, I'm sure I can. I'm a